Hello friends, I am Oshi Jain from Dr. Hari Singh Gaur Central University. I'll introduce you with a new and emerging field of inquiry, that is forensic psychology. I'll also discuss the meaning, definitions and a brief history of forensic psychology to introduce the field, scripted by Gyanesh Kumar Tiwari, Assistant Professor, Department of Psychology, School of Humanities and Social Sciences, Dr. Hari Singh Gaur University, Sagar, Madhya Pradesh, India. The presentation in this episode will follow the following order. Module 1, Introduction to Forensic Psychology. Module 2, Definition of Forensic Psychology. Module 3, History of Forensic Psychology. Now, Module 1, Introduction to Forensic Psychology. Psychology is the systematic study of human behaviors encompassing all of conscious and unconscious aspects of human experiences, feelings and thoughts, which seek to appreciate individuals and groups by establishing general principles and researching specific cases. Fernald 2008. It attempts to explore the role of cognitive, affective and behavioral processes in regulating the behaviors of the people in a variety of individual, interpersonal and group situations, taking into account the psychological and biological processes underlying these behaviors. The science of psychology seeks to understand and explore various mental processes encompassing attention, perception, learning, memory, emotion, motivation, intelligence, reasoning, problem solving, brain functioning, personality and thinking, to mention a few. The psychologists differ in their orientations of studying the areas of human functioning which are evident in development of different branches of psychology such as clinical psychology, industrial and organizational psychology, social psychology, positive psychology, forensic psychology, etc. Psychologists employ a variety of empirical methods in collecting, processing and analyzing data of qualitative and quantitative in nature. All these efforts are meant for inferring and establishing causal and correlational relationships between psychological variables. Following empirical and deductive methods, the researchers of psychology employ critical, constructivist and other inductive techniques to establish patterns and get insights into the nature and dynamics of behaviors. Since its inception, psychology has been lending support from other branches of knowledge, consequent upon which a host of interdisciplinary areas has taken shape, of which forensic psychology is one example. In a sense, the basic aim of psychology is to produce a set of knowledge which is objective, useful, unbiased and valid, with the help of which a cause-effect relation can be established and predictions can be made about human behaviors in a variety of situations across time and space. Forensic psychology is an applied branch of knowledge which relates psychology and the justice system. First, it aims to understand fundamental legal principles with emphasis on expert witness, testimony, competence to stand trial, child custody and visitation, or workplace discrimination. Second, an important task of forensic psychology is to testify in court as an expert witness, reformulating psychological findings into the legal language of the courtroom, providing information to legal personnel in a way that can be understood. Michael, 1986. Third, the forensic psychology also attempts to develop an understanding the philosophy, rules and standards of the judicial system. Fourth, it serves the expectations of legal needs and requirements. The forensic psychologists must have an in-depth knowledge of various statutes, laws and legal provisions framed, accepted and applied in country from time to time. Fifth, forensic psychology accumulates and applies knowledge and facts gathered in other branches of psychology such as clinical, social, organizational or any other branch of psychology. There are many subspecializations with forensic psychology which are communicated with the field to understand the legal facts and provide help and assistance to the judicial system to discharge its duty. For example, forensic neuropsychology assists the court to discuss cases that involve issues with the brain or brain damage. The forensic psychologists also help to decide the legal competency of a person to stand trial. Thus, the tasks before the forensic psychologists are not as such issues of general psychological facts, but they are shouldered with the responsibility to help understand the legal questions which deserve to be attended by experts of psychology background who are capable of converting them into the language the court understands. Forensic psychologists are frequently asked by the court to assess the competence of a defendant to face trial or to establish insanity of the person at the time of committing crime to ascertain criminal responsibility. In other words, the forensic psychology helps to translate psychological information into a legal framework. Other roles of forensic psychologists are to recommend cases for death sentence, psychological treatment, assessment of future risk and evaluation of the accuracy and credibility of witness. In addition to these, it also helps to develop recruitment, training, evaluation and assessment programs, police or other law enforcement personnel. Module 2. Definition of forensic psychology. Forensic psychology is an interdisciplinary branch of inquiry which facilitates the interaction of the practice or study of psychology and the law. First, according to American Psychological Association 2017, forensic psychology is a specialty in professional psychology characterized by activities primarily intended to provide professional psychological expertise within the judicial and legal systems. Second, the specialists of forensic psychology work in the applied settings such as prisons, jails, rehabilitation centers, police departments, law firms, schools, government agencies or in private practice. Third, sometimes it is also referred to as legal psychology or criminological psychology. Fourth, there is disagreement over the acceptable definition of forensic psychology to multifarious jobs done or expected from the experts of forensic psychology. There are two ways to define forensic psychology. In narrower sense, forensic psychology focuses on specific aspects of the field while ignoring other important aspects of the field. In this sense, when the experts of forensic psychology confines its concerns to clinical aspects and ignoring the social and other specialities of psychology which might also be related with the field in relevant manners. Otto and Halburn, 2002, argued that forensic psychology primarily focuses on clinical aspects of forensic assessment, treatment and consultation, and the forensic psychologists extend their clinical services to assess, treat or consult with the legal system. The other jobs of forensic psychology are to conduct research on eyewitness memory, decision-making processes of jurors, or to evaluate the effectiveness of offender treatment programs. Gudjonson and Howard, 1998, defined it as that branch of applied psychology which is concerned with the collection, examination and presentation of evidence for judicial purposes. In broader sense, forensic psychology is defined as, first, an elective efforts to conduct research involving the examination of the various aspects of human behaviors related to the legal processes. Second, the professional practice of psychology within or in consultation with a legal system that embraces both civil and criminal law. Bartle and Bartle 2006. Third, this definition focuses on both the application and research of forensic psychology. This definition has more acceptability as compared to the definition provided by the narrower definitions. Now, going towards module 3, that is the history of forensic psychology. After a thorough discussions pertaining to the meaning, scope and interrelated disciplines of forensic psychology, it is worth discussing the roots of forensic psychology. As a branch of inquiry, forensic psychology has a relatively short history which can be dated back to the late 19th century. In the initial period, psychological researches did not relate themselves with the inquiries which can be truly termed as the subject matter of forensic psychology. The psychologists who did some work of forensic nature did not call themselves as forensic psychologists. Their work gradually formed the base of forensic psychology, which can be said to fast growing. Based on Bartle and Bartle 2004 and Brigham 1999, a brief sketch of landmarks of history of forensic psychology has been portrayed in Table 1. Eyewitness testimony and suggestibility. The beginning of field, North America and Europe can be attributed to take initiatives to start studying scientifically some issues in the late 19th century which can be termed as the beginning of forensic psychology. The studies of that time did not earn the name of studies of forensic psychology. An expert in the field of mental testing, Cattell, a student of Wilhelm Wundt, established the first psychology laboratory at Columbia University in New York and conducted some experiments on the psychology of testimony, Bartle and Bartle 2006. Table 1. Some landmarks in the history of forensic psychology 1843, the development of M'Naughton rule for determining insanity in Britain. 1893, Cattell conducted the first experiments in North America on the psychology of testimony. 1896, the testimony of Schrenck-Notzing dealt with the effect of pre-trial publicity on memory. 1908, on the witness stand, a work of Munsterberg was established in the United States, which was criticized by Wigmore. 1909 to 1913, Whipple introduced North American psychologists to the classic European experiments on eyewitness testimony. In 1911, Verendonck conducted studies on the suggestibility of children in order to inform his courtroom testimony on their reliability. In 1917, Marston developed the first modern polygraph. Thurman used the psychological testing for personal selection in US law enforcement agencies. In 1921, in State v. Driver, a North American psychologist testified in court as an expert witness for the first time. In 1923, in Fry v. United States, the court speaks specifically to the issue of when expert testimony should be admissible. 1954, a note of social psychologists was cited in a footnote of the case of Brown v. Board of Education, decision prohibiting school segregation. 1964, Eysenck publishes Crime and Personality, in which he proposed his biosocial theory of crime. In 1968-69, the American Psychology Law Society, APLS, was founded, followed by the publication of Journal Law and Human Behavior. In 1980-81, the American Psychological Association's APA Division 41, Psychology and Law, was established. In 1993, in Daubert versus Merrill Dow Pharmaceuticals Inclusive, the US Supreme Court laid out specific criteria for determining when scientific evidence can be admitted. In 2001, the American Psychological Association formally recognizes forensic psychology as a specialty discipline. Cattell was trained in studying human perceptual and cognitive processes as Leipzig, Germany, who is known as the forerunner of studies of psychology of eyewitness testimony. He reported that people often exhibited inaccurate recall of things what they had witnessed in their everyday life. Cattell, 1895. Many small but important studies of eyewitness testimony and suggestibility began at the same time applying clinical and experimental methods. Ceci and Bruck, 1993, research by Binet on testimony of children was reported that the accuracy of the witnessed details was to be highly susceptible to suggestive questioning. In his experiments, he showed children a series of objects for a short period of time, followed by the instructions either to write down or recall everything in minute details presented to them. The study reported that the nature of the questions determined the nature of accuracy of the witness details by children. The least errors were committed in recall when the children were asked direct questions, whereas the greater errors were observed in the conditions where mildly or misleading questions were posed to them. These conclusions are reported to be true even by recent experiments on eyewitness memory. Ceci and Bruck, 1993. Following the study of Binet, William Stern, German psychologist, also conducted some studies with the objective to examine the effects of suggestibility on the accuracy of witness memory. Bartle and Bartle, 2006, Ceci and Bruck, 1993. He employed the recall and recognition methods to assess the eyewitness memory of the participants of the staged events. Then, they were asked to recall information about the event. It also worth to mention here that Stern was the forerunner of the reality experiment that is now used by eyewitness researchers to study eyewitness memory. In one of his experiments, participants were exposed to a scenario that involved two students arguing in a classroom setting until one of the students drew a revolver. Stern, 1910. Stern reported that the eyewitness testimony can be incorrect, and he also demonstrated that the level of emotional arousal of witness can have an impact on the accuracy of his testimony. These initial findings exerted significant impacts on the contemporary legal system. As a result, the psychologists in Europe were invited to appear in court proceedings as a witness's expert, which was mostly confined to the accuracy of eyewitness testimony. Albert von Schreneck, Notzing, 1896, acted as the first expert witness to provide testimony in court, showing the effects of pre-trial publicity on memory of a case involving series of 3 sexual murders. Bartle and Bartle, 2006. Schrenck-Notzing was succeeded to establish that extensive pre-trial in media significantly impacts the testimony of the witness. Bartle and Bartle, 2006. According to him, retroactive memory falsification process led to confuse the actual details of events with the details substituted by the events described of the media, and his claims were also verified by laboratory studies. Ruva, McEvoy and Bryant, 2007. It affected the contemporary trials of the offenders in Europe. Julien Verendonck, a Belgian psychologist, was asked to appear before the court as an expert witness in a murder case of a young girl. Cecily, in 1911. In multiple interrogations, the witness children exhibited dramatic change in their testimony and showed a large shift from unfamiliarity with the victim to providing details of appearance and name of the victim. On the basis of the other details of the case, Verendonk was convicted of the defendant's innocence. This led him to involve a series of studies with the specific intent of demonstrating the unreliability of children's testimony. On the basis of this experiment, Verendonk 1911 was able to demonstrate the inaccuracies of eyewitness memory of children, which were led by suggestive questions, and also helped him to conclude that the testimony provided by the children was likely to be inaccurate, and as a group, children are prone to suggestion. Ceci and Bruck 1993. These initial studies on eyewitness testimony of Europe had a great impact on the development of forensic psychology in North America, which was undergoing a different wave in criminal justice system. Hugo Munsterberg, a student of Wundt and father of applied psychology, published a book on the witness stand in 1908 in which he argued that psychology had much to offer the legal system. Bartle and Bartle 2006, Brigham 1999. In his book, he eloquently discussed the way psychology could contribute in the areas of eyewitness testimony, crime detection, false confessions, suggestibility, hypnotism, and crime prevention. Munsterberg was criticized for his comments on the then legal practice. Bartle and Bartle 2006, Wigmore 1909. Criticized him for the lack of relevant research publications to back up his claims, and more generally for the lack of applied research in the field of forensic psychology as a whole, which resulted in ignoring forensic psychology by the legal profession. But the impact Munsterberg exerted on the legal process was unavoidable. Bartle and Bartle 2006, and it paralleled a status in Europe. A host of crime theories were proposed which shaped the research and practice in forensic psychology with impact on American legal system. It led to establish first clinic for juvenile delinquents in 1909, use of psychological testing by the psychologists for law enforcement selection processes in 1917, and establishment of first forensic assessment laboratory to conduct pre-trial assessments in police agency in 1919. It acted in solid base for the forensic psychologists to involve in the judicial system of America. Bartle and Bartle 2004. In the State versus Driver 1921 case of America, the court for the first time accepted expert evidence from a psychologist in the area of juvenile delinquency. Although the court did not accept the argument of testimony of psychologists that the young girl was intellectually poor and her arguments deserved to be unbelievable. Lastly, in its ruling, the court accepted that the psychological and medical tests are practical and capable of detecting the lie on the witness stand. Bartle and Bartle 2006. Another case in this series was the case of Brown versus Board of Education 1954, which argued that separating children based on their race creates feelings of inferiority, especially among African American children. Benjamin and Cruz 2002. The Supreme Court agreed to this agreement and ruled that racial segregation of children in public school has a detrimental effect upon the colored children. The race denotes some or other kind of superiority and inferiority and affects the motivation of the children to learn as well as affects the educational and mental development of the children. Benjamin and Cruz 2002. It conveyed significance of the field of forensic psychology for the recognition of the Supreme Court of the fact that was accrued to research in the social sciences showing the harmful effects of segregation and inclusion of studies claiming that prejudice and discrimination affected personality development. It evinced the first time when psychological research was cited in a US Supreme Court decision and validated psychology as a science. Benjamin and Cruz 2002. In Jenkins versus United States 1962 case, The trial involved charges of entering assault and intent to rape, pleading not guilty by reason of insanity. The three clinical psychologists argued that defendant was suffering from schizophrenia at the time of committing the crime. The judge disregarded the testimony from the psychologists by arguing that they were not qualified to give expert testimony on the issue of mental disease. American Psychological Association, APA 2007. In its appeal, the APA came with a report that clinical psychologists are competent to provide opinions concerning the existence of mental illness, which resulted into an order of new trial. The court observed that some psychologists are qualified to render expert testimony on mental disorders. The determination of psychologists' competence to render an expert opinion must depend upon the nature and extent of his knowledge and not simply on the claim of the title psychologist. APA 2007. This decision enhanced the legality of the role of psychologists to contribute and involve directly in the legal system as expert witness. The summarized form of the whole episode can be: forensic psychology can be defined in two ways. In narrower sense, it tends to focus only on the clinical or experimental aspects of the field, whereas broader way advocate for less restriction and recognizing both the aspects. Forensic psychologists play many roles. Clinical forensic psychologists are primarily interested in mental health issues pertaining to law. Experimental forensic psychologists study any aspect of human behavior that relates to the law. The history of forensic psychology is marked by many important milestones, both in research laboratory and in the courtroom. Early research consisted of studies of eyewitness testimony and suggestibility, and many of the early court cases in Europe where psychologists appear as experts dealt with similar issues. Hugo Munsterberg played a significant role in establishing the field of forensic psychology in North America, and by the early 1900s, forensic psychologists were active in many different parts of the criminal justice system. Currently, forensic psychology is viewed as a distinct and specialized discipline with its own textbooks, journals, and professional associations. With all these information here, we come to end of today's lecture. Now this is the time for you to self-study. This is Oshi Jain signing off. If you want to learn more and enhance your knowledge, you may log on to our website for MCQs, quizzes, LORs, www.cec.nic.in. Hope you have understood well about these modules. Till then, keep studying and goodbye.